Hi, my name is Nick Weiss. I am the founder and owner of NP Weiss Law. I want to talk about modifying existing custody decisions. When we talk about custody, we are talking about a custody order that is entered into either in a divorce, in the domestic relations division, or we're talking about through unmarried people, and they've already had an existing order in the juvenile division of Ohio's Courts of Common Pleas. Custody is different from parenting time. Custody order will have both. They'll have a custody and they'll have parenting time order in it. But custody has to do with decision-making power. So that can be shared parenting, where both parties generally have the same kinds of decision-making power over the child. It can be sole custody, where one person makes all the decisions. It could be split custody, which is rare but can occur when you've got multiple children and one child is under the custody of one parent, one child is under the custody of another parent. In each of those kind of custody determinations or agreements, you could have extremely varied parenting time. If you are looking to change custody, and again, that is decision-making power, you need one of three things to have occurred. You either need everyone to agree, you need the child to assert that they want that change, or you need something substantial to have changed since the last time the court entered into a custody order. And that has to be something with the child themselves. That can't be because you moved, right? That means something has happened to the child that indicates to the court, or would indicate to the court, that a change in who has decision-making power should happen, right? And then the second part of that analysis is that change in the best interest of the minor child? So something has to happen to the child, with the child, for the child, that shows that we need to change decision-making power. This is different from if you just need changes in your existing parenting plan, right? Then you do not need to show that something substantial has changed in the child. You just need to show that change in parenting time would be in the best interest of the minor child. And that can include things like, I moved out of county. That can include things like the child has changed schools and they're now going somewhere else. And so me having more time is more available. And so I can provide that additional time with the minor child. So that is the key distinction. If you're looking to modify custody, you need a substantial change in circumstance. If you're just looking to modify parenting time, you just need to prove to the court that that modification in parenting time is in the best interest of your minor child. If you have questions about either or both of these processes, feel free to give our office a call.